Aloha. For Hawaii residents, protecting family is a top priority. We work hard to build a life for our loved ones and care for our aging parents. Yet, many overlook the one thing that ensures these efforts aren't lost during a crisis: a comprehensive estate plan. In this presentation, we will guide you through the essentials of Hawaii estate planning and how to keep control in your hands, not the courts. Many people mistakenly believe estate planning is only for the wealthy or the elderly. In reality, it is simply about control. It's the legal process that lets you, not the government or a court, decide who manages your finances, who makes your medical decisions, and how your legacy is passed down. It is a proactive strategy to handle life's what-ifs before they happen. A solid plan starts with 3 key documents. First, the durable power of attorney. This allows a trusted person to handle your finances if you cannot. Without it, your family might face a costly court conservatorship. Second, the Advance Healthcare Directive, which lets you appoint someone to make medical decisions and outline your end-of-life wishes. And third, a HIPAA authorization, ensuring your loved ones aren't locked out of knowing your medical condition during an emergency. The fourth essential document is the last will and testament. This is where you say who gets your assets and, importantly, name guardians for minor children. However, there is a common misconception here. Many believe a will keeps you out of court. Unfortunately, a will is actually the primary ticket to probate court. It guides the judge, but it doesn't bypass the process. So, why avoid probate? In Hawaii, probate is expensive, public, and slow. Even a simple estate can cost around $8,000 and take over a year to settle. If you die without a plan, called intestate, Hawaii law dictates a rigid formula for your assets. Surprisingly, this often means a surviving spouse does not automatically inherit everything, which can force the sale of a family home. For many Hawaii homeowners, a will isn't enough. If you own real estate or have assets over $100,000, a revocable living trust is often the better choice. It lets you maintain full control of your assets while you are alive. But upon your passing, those assets transfer directly to your beneficiaries, bypassing the courts, saving money, and keeping your family affairs private. It is important to note that a revocable trust avoids probate, but it does not protect you from lawsuits. True asset protection involves planning before trouble arises. This includes carrying proper insurance, like umbrella policies, separating business risks with LLCs, and potentially using irrevocable trusts. Remember, trying to move assets after you've been sued is often too late. Perhaps the biggest financial threat to a family isn't taxes, but the cost of long-term care. Many are shocked to learn that Medicare does not cover nursing home stays. Hawaii's Medicaid program, MedQuest, can help, but it has strict income and asset limits. Be careful with well-meaning gifts to children, as these can trigger a 5-year penalty period. Proper planning can protect a healthy spouse and preserve assets, but you must act early. Modern estates include more than just houses and bank accounts. We now have digital assets like cryptocurrency and social media accounts. Hawaii law requires you to explicitly grant permission in your documents for anyone to access these. Also, choose your representatives carefully. Whether it's an agent or a trustee, they need to be organized, trustworthy, and capable of remaining neutral if family tensions rise. Don't fall for the myth that you are too young or that an online form is good enough. Generic forms often fail to meet Hawaii's specific legal nuances. If you have married, bought a home, or haven't looked at your plan in 5 years, it is time for an update. Estate planning is about peace of mind. Contact Okura and Associates to help navigate these waters and ensure your ohana is protected.